तो अब सीन क्या हुआ इसका? सीन ये हुआ कि अशोक की पान की दुकान है, कुक्कू पहलवान वहां पे आए और गोलियां चली। कुक्कू पहलवान के गया, पीछे से निकल गया, अशोक के बाह से गया, दूसरी कान के पास गई। एक यहां से गई है,
दूसरी गोली
नहीं लगी। कंप्लेंट अशोक है और ये चांस विटनेस राधा रतन है और दीपक अग्रवाल है। Conviction is based on
testimony of PW 13 Radharaman
and
Deepak Agarwal,
because Ashok has turned hostile.
नहीं लो,
हाँ,
अशोक दीपक अग्रवाल हॉस्टाइल डिक्लेयर हुआ, लेकिन उसने उतना पोर्शन कहा, उसको डील किया, और अशोक और राधारमण।
हाँ, बट जहां तक अशोक और राधा रमन का सवाल है, अशोक आई एम सॉरी दीपक, इनकी एविडेंस जो है, दोनों हॉस्टाइल हुए हैं? नहीं, एक हॉस्टाइल हुआ है। टू द एक्सटेंट दे एक्सेप्ट द फैक्टम ऑफ occurrence of the incident and sufferings of the deceased and that of accused Ashok. These two aspects can be culled out from the testimony of Deepak, which is corroborated by Radha Charan Sharma.
To some extent.
Naturally, but he also admits the fact that there was an incident and गोलियां चली, और he also says about the seizure and collection of that blood soaked earth and plain earth, तीनों चीजों। अब इनका अगर ये statement, if we juxtaposition it with that of Ashok's statement, so what is the scope of contradiction? I'm reserving you 2 points different. That body was removed at 10:30. Spot map was prepared at 10:40. Without that body, how could there be a spot map? As you have argued, there is no recovery of gun from the accused, from the convicted persons. Whosoever was found to be in possession of gun is not. He has been acquitted.
Yes.
And
not even a single shell was recovered.
Not recovered. So neither gun is recovered, nor shell was found. And except the fact that person against whom some rivalry is going on,
yes,
with intention for false implication, he has which has come in the statement of Raja Rabban, with Ram Vilas, उसमें गवाह है, and Ashok is one of the accused persons. This is your argument.
Ocular evidence और medical evidence देखें तो ये
corroborating है. हाँ, corroborating.
Other facts हैं, जैसे अशोक शर्मा.
Now, what is the law? You tell me the law. Suppose medical evidence, see, there is a vulnerability areas in all the three things, whether it's an ocular evidence, or it's a medical evidence, or it's a seizure, और फॉर दैट मैटर बैलिस्टिक्स रिपोर्ट। ये तीनों जो डायमेंशंस होते हैं मर्डर के केसेस में नॉर्मली और भी केसेस में, इसमें स्कोप ऑफ वेरिएशंस काफ़ी रहते हैं। कभी विटनेस हॉस्टाइल हो जाता है, कभी मेडिकल की रिपोर्ट कॉन्ट्ररी हो जाती है, कभी सीजर्स नहीं होते हैं। नाउ हाउ सुप्रीम कोर्ट हैज एड्रेस्ड सच सिचुएशंस? अगर मान लीजिए कि ऑक्यूलर एविडेंस और सीजर मैच करता है, तो व्हाट इज द वैल्यू ऑफ द मेडिकल एविडेंस? एक, अगर ऑक्यूलर और मेडिकल मैच करता है, उसका वैल्यू हुआ सीजर क्या होगा? सीजर नहीं है मान लो, और अगर मान लो ऑक्यूलर एविडेंस नहीं है बट circumstantial evidence है, which is supported by medical evidence and the seizure. What is the view? Now, three combinations.
अशोक यदि मेडिकल में मेडिकल
इस पर हमको आप सुप्रीम कोर्ट दिखाओ.
जी लो
देखो अब आपके केस में क्या लगेगा, आपके केस में लगे कौन सा कॉम्बिनेशन है. नाउ मेडिकल एविडेंस एंड ऑक्यूलर एविडेंस
कॉर्पोरेट
both are corroborated, but there is no seizure.
even circumstances doesn't speaks
What should be the approach of the court? Now, let us see how Supreme Court reacts to such situations. Because as far as I understand, ocular evidence is of paramount importance.
yes
Number one, unless it is pregnated with vulnerability, meaning thereby that if you can criticize it, for example, one of the reason is that there is a rivalry going on. He is an accused in the case where Ram Lakhan's brother was shot dead. Ram Vilas is a witness. So to some extent, you may argue about the fact of bias or malice or well, no, not these words rather. I should say that he is an interested person to implicate them falsely. But if this ocular evidence is supported by prosecution witnesses to the extent that one Maruti car came there was gunfire shots, two persons had come in. Now, the innocence of Kuku Pehlwan is also of some importance, because there was no enmity of Kuku Pehlwan with any of these persons.
नो इंटेंशन टू किल लेकिन फिर भी यदि एक्सप्लेनेशन देखते हैं तो
No. I am not restricting my submission to this extent only. What I am saying is that people had come to shot Ashok. Gun shot was fired, bullet was fired to aim it at Ashok, because there was no enmity between Kukku and Ram Lakhan or Ram Vilas. So the previous enmity between the Ashok and the assailants cannot be ruled out even otherwise also, because there is nothing on record to suggest that Kukku had any animus with the accused persons. So Kukku became victim of the animosity between the assailants and the complainant. So naturally, because Kukku is dead because of the gunshot injury, it's really a case of murder, as we have discussed the other day. But this is established that some persons who had come there had aimed Ashok for gunning him down. But to his good luck, he escaped. But Kukku fell victim at the hands of assailants. So in such situations, what should be the approach of the court?
केस लॉ
Because we have to take a holistic view. Well, जैसे last time also we discussed it, that the meaning of beyond reasonable doubt is now further qualified with a different phrase, high degree of probability. It may be a good law, may not be a good law, that's a different issue. But as on date, Supreme Court has ruled that there should be a high degree of probability, because now the modus operandi of the criminals have changed. There are many ways now things are being done indirectly. So it is very difficult to establish a direct link or nexus with the main accused persons. So therefore, they connect each and every piece of evidence to reach to a conclusion, the high degree of probability. So in that context, you have to address us and educate us also rather as to what should be the approach of the court where you have ocular evidence which has withstood cross-examination, supported by medical evidence, but there is no seizure. These minor aberrations about preparation of spot map and other things indeed shall have its own significance, but to what extent it can influence the judgment is also to be seen. in the wake, in the light of or in the teeth of such evidence placed on record. अब आप प्रोसीड करें इसके आगे.
इसमें लॉर्डशिप तो 3W6